If you live in a community with a homeowners association, you have probably wondered what actually happens if you fall behind on your dues. Can an HOA really take your house over a few $100s in unpaid assessments? The short answer is yes. In most states, an HOA can eventually foreclose on your home over unpaid dues, separate from your mortgage. But it is not usually the first thing that happens, and it is not a surprise sale. State law and your community's governing documents require a notice-and-lien process first, and in some states a judge has to approve it before a sale can happen at all. Here is why this is even legal. When you buy into an HOA, you also buy into a recorded declaration, often called CC&Rs, that legally obligates you to pay assessments. Only a minority of states have actually adopted the Uniform Common Interest Ownership Act, a model law drafted by the Uniform Law Commission. The real authority comes from each state's own HOA statute, together with your recorded CC&Rs, and most of those statutes give the association a lien for unpaid assessments. That lien generally attaches automatically once dues go unpaid. This is also a growing problem in 2026. South Carolina's Department of Consumer Affairs logged roughly a 111% rise in HOA-related complaints between 2019 and 2025. And Georgia just passed a 2026 HOA oversight law, Senate Bill 406, that now requires associations to register with the state and doubles the minimum unpaid dues threshold before an HOA can foreclose, from $2,000 to $4,000. So let's walk through how unpaid dues actually become a foreclosure. It starts with missed dues, billed separately from your mortgage. Next, a late fee and interest accrue on the unpaid balance. If the debt is not resolved, the association records an assessment lien against your property in the county land records. And if that lien is never paid, the final step is lien foreclosure, either through a court case or, in some states, a non-judicial sale. Before any of that final step happens, an HOA usually has to do several things first. It has to send you a written notice of the delinquent assessment before it can even record a lien. In Florida, for example, state law requires a 45-day pre-foreclosure notice under Florida Statute 720.3085. The association also has to give you a window to pay and cure the debt. And in some states, like Georgia under its new law, it has to meet a minimum debt threshold and a registration requirement before it can foreclose at all. Not every state handles the actual foreclosure the same way. There are two broad paths, judicial and non-judicial. In a judicial foreclosure state, and Florida and Texas are both examples, the association has to sue you in court, and a judge has to approve the sale before it happens. Some states add extra protections. Texas bars an HOA from foreclosing on debt that consists only of fines, requires it to go through a court, and lets a former owner redeem the home within 180 days after a sale. In a non-judicial state like Nevada, the association records a notice of default, and under Nevada Revised Statutes 116.31162, the homeowner then has 90 days to pay and stop the sale, without a judge ever getting involved. So what should you actually do if you get a lien or delinquency notice? First, read the notice carefully and note the exact amount claimed and any deadline to cure. Second, request a full itemized account ledger from the HOA in writing. Third, ask about a payment plan. Fourth, pull your own state's assessment lien statute and your community's CC&Rs before assuming foreclosure is imminent. And fifth, if a lien has already been recorded, consult a local real estate or HOA attorney promptly. A few mistakes tend to make this worse. Ignoring notices because it's just an HOA is a common one. The lien and the legal process behind it are both real. Assuming your mortgage lender will step in is another. HOA liens are usually enforced completely independently of your mortgage. Paying partial amounts without a written agreement can backfire. and waiting until a lawsuit is filed before asking for help puts you in a much weaker position. When should you bring in a lawyer? If a lien has already been recorded or you've received a notice of default, a summons, or any court paperwork, that is the moment to consult a licensed real estate or HOA attorney in your state, early, not after a sale is scheduled. To recap, yes, HOA foreclosure over unpaid dues is real and legal in most states, but it follows a defined notice and cure sequence, not a surprise sale. The exact process depends entirely on your state's statute. Read every notice, request your ledger in writing, and get a lawyer involved early if a lien or a lawsuit appears. This video is general education, not legal advice, and laws vary significantly by state. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and edited for accuracy before publishing. If you are facing an actual HOA lien or foreclosure notice, talk to a licensed attorney in your state.